All right, guys. Today we are lucky to have the president of the Bonnie Henry Fan Club in studio. Kip, what's up, man?
Good to see you again. It's been a while.
Can we start with, for people who maybe haven't seen you before, I mean, you're pretty well known. You've been spearheading a pretty big movement for us. Thank you, by the way. Maybe a quick 30-second recap of what you've done, like in grade 2 language.
Sure. So, and just for the record, it's not just me. It's a team, and they work wonders behind the scenes. I'd like to give them all a shout out right now, but I'm the executive director of a small nonprofit called the Canadian Society for the Advancement of Science and Public Policy, or just CSASPP for short. And we're a BC nonprofit, and our mandate is published on our website. But right now, and since inception, it's been to basically hold everyone accountable in government who was responsible for enacting those mandates relating to the lockdown. So that meant everything from the declaration of emergency, all the public health orders, the restrictions on public gatherings, social distancing, all of those things. We challenged all of that, beginning with sort of the foundational premise, which was the declaration of an emergency, which begot all the other measures. And
so you're on the naughty list.
We're on the naughty list, yeah. For sure, yeah. And that's not my main job. My main job is I work in tech, but this is on the side. This is my civic work. And we commenced a class action. I believe it was, early 2022. It's been so long. That's when we started it. And then it was within weeks of doing so, we filed suit against the provincial government and Dr. Henry. There's been a lot of different legal challenges regarding COVID measures, but ours was different in that it was a class action. So it's not one person with a grievance about not being admitted into, a restaurant or being able to go to church or places of public gathering or whatever. It was not like that. It was on behalf of an entire class of people, so a few million people, basically everyone who was affected by the COVID measures above the age of 18 at the time they were enacted. And it's entirely crowdfunded. I don't take a salary. The team doesn't take a salary. We're entirely funded by donations from the public. And, actually the other side is crowdfunded too. It's just not voluntary, the participation. But that campaign began quite some time ago. We commenced a class action on behalf of a couple million people here in BC. And there was a kind of a hurdle, a hoop that you need to go through in class actions where you have to get what's called certified. So you bring an application to the court, and the judge has to decide whether or not this should be able to proceed as a claim brought by millions of people, or because that's what distinguishes it from a normal suit where you've got one or two people suing somebody. In this case, you've got a large number of people. And so there's a test that's supposed to be applied for that. But that the Class Proceedings Act is the legislation that enabled people to bring class actions, and that was created back in, I think it was the early or mid-90s by the NDP government, then NDP government. I don't know if it was Mike Harcourt or who was the premier at the time, but it was introduced by the Attorney General to solve a public policy or a social issue at the time. There was a problem with women's cosmetic implants. There was a lot of problems with how they were manufactured. There were a lot of injuries. There were even deaths in some cases. And there was a concern that was going to jam up the court system if you had all of these people who had implants bringing suit against the manufacturers or whoever it was that they thought was responsible. And so this legislation was tabled so that you'd have sort of a collective avenue for redress. We're not the first ones to do that. Other jurisdictions have something similar. Ontario has a Class Proceedings Act. We have a Class Proceedings Act. But when that legislation was introduced, one of the reasons that the Attorney General, the NDP government at the time, it was a government-sponsored bill. The reason why they gave Parliament wasn't just what I told you, but also to protect people from their own government that was in the parliamentary debates. Everyone's forgotten about that. That was the NDP government. So we use that tool, and that legislation says you have to get certified before you can move on to the next step. So before you can go to trial, before you can deal with evidence, before you can put people on the stand and ask them questions and give live testimony, you have to get over that procedural hurdle. And the way the legislation is drafted by Parliament is it's not supposed to be a difficult, onerous step. But we knew that Crown was going to make it onerous, and they did.
To get certified.
Yeah. It was very death by 1,000 paper cuts. It's usually how they do it. And so we got our decision back. I think it was in late October of last year. And the public was quite incensed with the decision that Justice Crerar, who's our presiding judge, had released. It was very long. It was 144 pages long. You don't normally see decisions of that length, but he sat on it for around 2.5 years. I don't know exact amount of time, but it was a significant amount of time. That for some decisions, like the thing is that there's no requirement that says a judge has to issue a decision within X number of days or months. There's some jurisdictions where there is a requirement, not in BC. I don't know of anywhere in Canada. And because of that, this court backlogged with other cases. We had to wait 2.5 years, and we had no control over that.
For certification.
Exactly.
To decide whether you can proceed with the class action lawsuit. Wow.
Exactly.
Okay, so then did you get it?
We did not. And the reasons that he gave, and again, there are 144 pages, and so I'm not going to be able to synthesize all of them, but in a nutshell, and there were a bunch of reasons, he felt, because Crown had convinced him, which is Dr. Henry's lawyers, that this case was too big. In fact, he described it as the largest class action in Canadian history. That was his own words. And he kept on describing it as large. And I had some time to think about that, and I'm not really sure what he means by large. Maybe I'm an engineer, and so precision of language matters. I thought it mattered in law, but it matters a lot less there, because large can mean multiple things in litigation. Like, does that mean the amount of documents that are produced? Because the court sees like patent cases for some pharmaceutical company that you released a drug that hurt people, and there's millions of pages of documents. There's lots of cases like that, or litigation with the CRA. There's been many instances where there's been entire warehouses of documents that potentially would be produced. So I don't know what he means by that. That shouldn't be a barrier to justice. If he means in terms of like the number of lawyers that are needed, maybe there's something to be said there, but there's no rule that says you have to have X number of lawyers in order to go to court. Some people don't have any lawyers at all when they go to court. So what does it mean by large? And I think what he unconsciously was saying was that he was really talking about the magnitude of the government's interests that were at risk of being displaced.
Of course.
That's what I read, and that's not a valid reason to dismiss an application for certification. The test is set out by Parliament, and it's not a long test. There's been many interpretations of that statute over the years, but anyone can read it in like less than 5 minutes. It's not long. But the problem is that whenever Parliament creates laws, they don't explain all of it about how they should apply in a given circumstance. In the British tradition, that's delegated to judges to interpret. And that's sometimes where the problems start, right? Because judges, they don't like to see themselves as public policy makers, but for centuries they have been in kind of a less obvious way. That's just how the common law is. And Crown went to great length to try and make this statute, the interpretation that the judge should apply, be much more complicated than it really was. And so one of the things that they said was, look, because you have to be a suitable representative plaintiff, like that represents this class of millions of people. And obviously our stakeholders are happy with our work. But I don't think it would have mattered who was the proposed representative. That would have been an issue for them. And so the statute does say they need to be suitable, but it doesn't really define what that means. And so Crown took that to say, well, they don't have enough money. Right? They don't have enough money in order to prosecute this, to bring this all the way to trial. So you should just throw it out.
What?
Yes. And it sounds absurd, but the obvious danger with that is just forgetting COVID stuff. Just imagine there was something else that happened. Like say there was, a defective product recall or, some cereal that had arsenic in it and lots of people were dying. The manufacturer could just raise as a defense that, look, we've killed so many people that this is, the mess is too large that we shouldn't be held accountable. And like the plaintiffs, they don't have the resources to bring, a large multinational to account.
Our victims don't have enough money.
The victims don't have enough money. And so that's a problem, right? Because one of the reasons why the Class Proceedings Act was created was to facilitate collective access to justice. So there's been this problem that's been going on for centuries where we have elected representatives who make laws, but the laws they're not complete until a judge interprets them. And then there's a lawyer who also wasn't elected who's explaining how that law should be interpreted. And so they become a lexicographer. They tell the judge what the word reasonable means in this context. So there's always been that vulnerability in the system. It's not perfect. There's some good things about it, some bad things. But the bad things is what they leveraged in this situation to try and dismiss it. That wasn't the only reason. That was the main central one in my view, was just that this is too big.
Hey, it's Kid. Listen, the power of microdosing is undeniable at this point. You've listened to podcasts, you've read things about it, but you got to be using the best of the best. Mindful Meds is the gold standard. Website is mindfulmeds.io. I have a promo code. You can save 15%. Just use Kid Carson at checkout. And I take a look at Brainbow and Social Spark, which is a blend I helped create with Mindful Meds. Visit mindfulmeds.io.
There were a lot of, my inbox was jammed up and people were calling and
so you weren't even given the opportunity to go to court and present your case, basically.
Exactly.
Yeah.
But he was evaluating things on their merits. For example, he said that Bonnie Henry is immunized from any liability. That's not an issue that an application judge should be determining on a certification application. That's something that should be punted down the road to trial. He's just supposed to determine whether we meet the test for certification, not whether we're correct that she's done something wrong, right? So there was an issue of like advocacy here.
So they wanted to really nip this in the bud.
Yes.
Whatever. Is it nip it in the bud? Nip it in the butt? I'm not sure. Whatever.
In the butt.
Whatever.
And the thing is like, why did it take 2.5 years? Because the decision, even if it was a correct decision, it didn't need to be 144 pages. It could have been 30 pages, and the decision could have been the same, and it could have been released within 3 months. And there's case law now, especially in England, where we've all heard that expression, justice delayed is justice denied. But you now have judges who are confirming that in their decisions, that they have a 3-month rule in England. Anything longer that, and they say it undermines public confidence in the judiciary, commercial confidence of the business community, just the public. Everyone loses faith in the judiciary because you don't have any certainty of what you can and can't do or what someone ought to be doing in the world if you don't have access to timely decisions. Someone's got to make a decision, right or wrong. But if you sit on it for 2.5 years, but I think that was not an accident. I think I'm not going to say that the court is corrupt, but it does feel that the outcome was predetermined early on. And the reason I think for the 2.5 years was strategic because we all remember what it was like a couple of years ago. Like, it was madness and mayhem in the streets. People were getting arrested. There were riots. There were protests. There were police trampling over people on horses. It was a pretty insane time. Like, there were a lot of unhinged people on both sides, right, of the fight. And that was a concern for me, because, that's one of the reasons why we brought this suit, is like, Canada's supposed to be a civilized society. If we have a problem, then we have avenues for redress. We don't need to resort to riots. That's what the government tells us, at least, right? And so this could be a useful pressure release valve, is rather than people starting fights or, trying to do something harmful to a public official, is we go to court. I think the reason why they took 2.5 years was not because it required that much reading and thinking. I think it was because the risk of civil unrest at the time that we were in court was significant. And I don't think there's anything controversial about that. I think the government's lawyers would agree with, everyone knows that it was a time of mass civil unrest, and releasing a decision like what Justice Creer released at that time would not have helped. It would have dumped gasoline on the fire. And it's well known in the bar that public confidence in the judiciary is not doing well. I was actually just reading a paper on that before I came here. It's been going down over the years, and so you release a decision like that at the climax of public sentiments, and it's not going to help. So I think what they thought they could do was wait until everyone kind of forgot about it and public sentiments attenuated, and then you kind of mitigate that risk of
everyone's moved on.
Everyone's moved on, and the economy is racked down everywhere, so people can't contribute and donate and whatever it is that they need to do, because that's just life, right?
Yeah, I mean the world is even crazier than it was then.
Yes, exactly.
Well, so they're like, okay, if we announce, sorry, no, we're not going to let you go to court. A few years ago, yeah, people would have just freaked out.
They would have freaked out. Yeah.
So now it's like, we release it quietly.
Yes.
And people are people paying attention?
Some people. Some people are. A lot of people who are very anti-lockdown don't even know about our work. We found out recently we had been shadow banned, it appears, on social media, which
funny.
Doesn't surprise me. But that kind of makes sense, because I meet people all the time who get really angry when they find out about our work, because they're like, why didn't I know about this? Like, how long? Looking at your status updates, your website, like, I just found the Kid Carson interview from 2020. Why am I just finding this now? And I'm just like, I don't run the Silicon Valley tech companies. I don't know how they moderate and how those algorithms work. I'm a software engineer, but I know that human beings have their fingers over the levers and knobs. So, and I don't know who those people are. They never talk to us. But if you haven't heard of us, it may not be an accident, because we have an audience around the world, right? In Germany, in the UK, in Australia, the United States. We have people calling us from Texas. No surprise. So if you're in this country and you haven't heard of us, it's probably not an accident.
Damn. So this has come out. What's next? I mean, what can you do next?
We have an opportunity to appeal it, and you have to start the appeal process within 30 days of that decision. So that window has already come and gone, but we started that process in time. That first step is just, you don't really have to do much. You're just basically giving the other side notice that you're going to bring an appeal, and you file this form in court, and it's not very complicated. But the actual substantive work of analyzing his decision and picking it apart, all the problems that are with it, that goes into what's called your factum or written submissions, whatever it is they call it in the Court of Appeal. But basically, it's your argument of everything that he did wrong, and that takes time. That takes a lot of time to, like a good lawyer on a case like this, even like 2 weeks is short runway. Our deadline to file that was originally the 30th of last month of April. It got punted down the road by a month because both sides needed additional time, and there were some, one of our counsel had a personal matter to attend to, and so that worked out well by coincidence that we have some additional runway. But that's the 30th of this month, which it is, for those listening, it's right now, it's May 2026. What's the date? I think it's the 10th.
Yeah. 9th, yeah.
9th.
Mother's Day tomorrow.
Mother's Day tomorrow. Can't forget that.
We've come in the studio late at night on the 9th.
Exactly.
To record this emergency podcast.
Well, so we have to fundraise. We have to fundraise in order to see this through to the end, because people need to understand that this decision is permanent unless it's altered. That's the way common law jurisdictions work, is you have a decision and there's this idea called stare decisis. It's Latin. It just means that the past decisions are binding on a court. Like there's some nuance to that, but in this case, this is a decision that is favorable to the government's interests, and they will hop on it. And it's already breaking things in the world that you wouldn't expect. I saw recently there was a gentleman who was being sued by RBC, and our decision came up in court. It was cited. I think he had borrowed some money from the bank for his business. It was some kind of a loan. And I'm assuming it sounds like he defaulted on it, and the bank went after him. And he said, and if it hadn't been for the lockdown, having all of us living through it, we might have found this to be kind of a spurious argument. He said, look, I had a business, but it was in ruins because of these public health orders. And the judge cited our decision saying, you can't blame Bonnie Henry, she's immunized. And so that's what I mean, is that decision, it's going to break all kinds of things in the world, that it will always come back to haunt people forever. Because this is the kind of decision that the government needs in order to rationalize any absurdity that they do in the future, where there's an overreach of executive authority.
And not just for COVID, but
it could be anything, and it doesn't matter where you sit in politics. If you're sympathetic with Indigenous rights, it will come back to haunt them. If you're sympathetic with people who are more on the right about asserting property rights and things like that, it's going to come back to haunt them. It may eventually even come back to haunt the government itself, right? Like, because right now the BC government is going after some pharmaceutical companies that were involved in the fentanyl crisis, right? If I was corporate counsel for those companies, I would be instructing my BC counsel you may want to look at that decision, because they're saying we've created such a mess in the province, and we can argue that the BC government doesn't have the resources in order to see this through. They're broke, right? So this any number, it will break everything for everyone. And if that decision is left to stand, it's going to cause a problem. So this is our last avenue for collective redress. And I'm saying that not metaphorically, but in actuality, because there's a law in Canada in BC called the statute of limitations, and it's similar in other jurisdictions. It's basically a clock that starts ticking as soon as you know, or you could have known, that you might have a claim that you'd like to bring to the court. And in BC, it's 2 years under the Limitations Act. And once that clock has expired, that's it. There's been cases. There was one years ago. There was this family whose loved one had been killed in a correctional facility. It was caught on camera, and the correctional staff had actually murdered the inmate. And so there was no controversy about who was responsible for it. But they brought their claim just like a few days after the 2-year window had expired. And the judge was very sympathetic, and he said, I have to throw this out. Like, I can give you what you want, but the other side is going to appeal it, and they'll win. So the statute of limitations is like the system's broom, right? And this is the last thing that's in the system that's collective redress for everybody. So once it's gone, that's it. There's no going back. That decision will be binding forever. So we have to see this through, and we have to see it through to the end. Otherwise, we can't complain later. Does that make sense?
Yeah, it's just, I'm sweating. I'm having like PTSD.
Hey, it's Kid. Shout out to friend of the show, Nicole Gilmore, one of the Lower Mainland's best real estate agents. She's awesome and awake.
As a single person listing a house, it's a little bit intimidating because there isn't like the other person on your shoulder to ask questions or advise or collaborate with. So Nicole was super instrumental in helping me focus and on the tasks that needed to be done. And she kept me moving along. And as my accountability coach towards listing, I actually did move the process along, and it got to a place where we could list, and I'm so happy with the results.
GilmoreRealEstate.ca.
I didn't mention this, but throughout that time, Justice Crerar periodically would write us and opposing counsel as well, saying, there's this new decision that's come out from some other court somewhere in the country. It might have a bearing on your application that's before me for certification. If you'd like to make submissions on it, you're welcome to do that. And so sometimes he would start that process. Sometimes we would find a new judgment that was helpful for us. Sometimes Crown would bring it to his attention. And this went on. I think there was at least 6 instances where he asked for basically more information on how this might be relevant to his analysis. And the parties cooperated. But every time that happened, it would delay things further. So he'd say, I'm going to have my decision, I expect, within the next month and a half, 2 months, whatever. And then just before that time had passed, he'd say, by the way, I just found this new decision, and then pushes it back another 6 months. But when we read his decision, there was very little of that post-certification analysis, the feedback that he needed, and all these other decisions, that was actually contemplated in his decision. So that's my theory that this was a stalling tactic isn't totally without any grounding. But yeah, it was frustrating. It was frustrating because everyone was like, this decision didn't need to be 144 pages, and it certainly didn't need to take 2.5 years.
Okay, so what happens at this point? You've got to raise some money.
We have to raise. So originally we thought we needed 70,000. Turns out we don't need transcripts of everything that was said to the judge for this. So that saves us some money. We need to raise around 50,000. It's not a lot. I've seen people raise significant amounts for other campaigns that affected far fewer people.
Oh, we've seen GoFundMe's for.
And that's where we are. We're on GoFundMe, right?
Oh, yeah, okay.
Yeah.
Okay. Can I put that link in the?
You absolutely can.
Yeah. Okay.
Yeah. You can absolutely put it on there. But our problem is that a lot of people don't know about us. Some people know about us, but they are lacking confidence in the judiciary, and I can appreciate that. I can definitely appreciate that. Nobody's really saying that we've done a bad job or anything like that. We always take criticism seriously. People have constructive criticism. It's rare. Most people actually really support what we're doing.
But you're the only people doing this.
It's because class actions are complicated, and I have...
Were there other people also wanting to file a class action?
Yes, but they don't really understand how to do it because most of the people, when they were upset about the lockdown, they were upset about specific grievances that affected them. I think I may have mentioned this actually last time I was here where, a buddy of mine, he was upset that he couldn't go into a strip club. Another guy was upset he couldn't go to his church. Somebody else was upset that they couldn't go to Canadian Tire to pick something up. Somebody else was upset, and this one was me, couldn't see Dune in theaters. Everyone had their own grievances, right? And I told people, look, if you want a solution for this, you have to put your individual grievances aside and think about everybody. That's the only way, because there's no one demographic that wasn't affected. Everyone was affected. Even if you were rich and you had a private jet, you probably, when you landed somewhere, still had to submit to, rapid antigen testing or something like that, right? Everybody. So if everyone is affected, then everyone should bring a class action. That's what this tool is for. But trying to get people, I would say our followers are across the political spectrum, but there's a large portion on the right. The left tends to think more collectively. The right tends to think more about individual issues, things that affect you personally. And there's a time and a place for both of those in different issues. But for something like this, you can't think at an individual level. everyone was being screwed over, right? And it was very hard to get people out of that frame of mind where they couldn't stop thinking about themselves. Because people do that in dire times, in emergencies. That's just how people are. If you're in a car accident, your building is on fire, you're thinking about yourself. Unfortunately, that's just how most people are. So in a situation like this, when people wanted to litigate, and there was a lot of people who wanted to bring legal challenges, they were doing it in the wrong way. So they were challenging on technicalities and in the rules. A lot of people were bringing what was called judicial reviews. And it's a type of procedure and law where you're challenging a government's decision, right? And that's not, you're not supposed to be challenging policy measures normally through judicial review. And people basically were challenging things that were downstream rather than the cause. So, for example, they didn't like an order that prevented them from public gatherings at places of worship, right? But that order was predicated on a declaration of an emergency. But they were just so fixated on what happened at their church. It's like, no. As long as you don't deal with the declaration of emergency, the judge is going to say, yes, but there was an emergency, so they had to do that, right? And they'll win. And that's what happened. I told people this, a lot of people didn't listen, but that's what happened in all of those cases, is they didn't challenge the underlying declaration of emergency. It's like a tree, right? You've got the root, and you've got all these different things that are predicated on the base. And so you have to challenge the base.
And by the way, just off the top of my head, I'm thinking about that one judge that came out and said that Trudeau did break the law by issuing the Emergencies Act.
Yeah, no, it's
Did that have any effect on anything?
Well, it's good that you raised that. I think that was one of the decisions. I don't actually. So, the most recent footnote in that narrative, that saga, postdates the release of Creerar's decision. But it's important that you raise that because, yes, there have been success. To those who say there's no hope at all in the judiciary, I would rebuff that by saying, actually, we have enjoyed successes. There have been successes, intermediate successes, some more technical than substantive. But there's some very important ones, like in Alberta, for instance, all of the public health orders the chief medical officer issued were struck down as ultra vires. Ultra vires means... Vires is from Latin. It means no power, basically. The law is of no force in effect, right? And all of them were struck down. Not because, there was an issue with the policies themselves, that they were far-reaching or they weren't supported by science or anything like that, but it was a technical victory because Cabinet was issuing those orders, or was kind of shepherding the chief medical officer, Dina Hinshaw, into issuing them. And they don't have the Parliament hasn't given Cabinet the authority to do that. That's what their chief medical officer is for. And so on that technicality, all of those orders were struck down. That's good, but it's not
right. That was in Alberta?
Yes, so that was in Alberta.
So all the mandates that were handed out in Alberta,
yes, were all struck down.
Were illegal.
Yes. But
so people who are getting in shit for...
And people can bring claims now for, like, if their business, all those damages that they suffered, they have a claim now, and the clock will restart from the date of that decision. That's usually how it works. That's when the world has been put on notice, statute of limitations. Oh, it looks like the government broke the law. Before that, it was following the law.
So it's great, but it's on a technicality because the order came from the wrong people.
It was on basically,
how could they make that mistake? It seems silly that...
Well, the way the government, I wasn't there at the hearings, but if I read their factum, it probably would be fog of war type arguments. Everything was happening so fast. It was all in flux. We did the best we could. We might have made mistakes. But we did what we thought was necessary based on the best evidence that we have. And obviously we know now that a lot of people in government did know better.
It's all bull.
It is. Yeah. But so that's the thing, is basically the orders were on the wrong letterhead, and so they were all struck down. And sometimes, that's often the only way that you will have a victory, is by looking for those that technical minutia of did the decision maker have full evidentiary record? Did they look at this document and that and so on? And so people are trying to challenge substantive public policy through technicalities in the law, and that's what judicial reviews do. But at times, but that's really not the right tool, because you don't get discovery in judicial review. Discovery is where the other side, both sides have to hand over all their documents, right? Judicial review, it's much more limited. And so I knew that if we were going to do this right, there's so many incriminating documents that have come out, we need to see all of them. And plus, my team has constantly been getting an influx of documents from the public, and we can't do anything with them until we get into discovery, which happens after certification, of course, in class action.
Which you were turned down for.
Exactly. And
because
so
they don't want they
don't want that.
They know you're going to bring the heat.
Exactly. And that's the thing, is that class actions, they require certification, and certification has to happen before discovery. But that's one of those things where, like I was telling you, the legislature, when they created the Class Proceedings Act, it doesn't say anything in there about discovery has to get punted down the road. That was something judges created, and a lawyer convinced them at some point in time that this is the way you should do it. It's in the interest of justice. It will save court resources. It's fair for everybody, whatever. And so they use that against us, because we have a lot of incriminating documents.
You shouldn't have acted so smart. I'm telling you.
But it's the drawback of doing class action, right?
You should have walked in there. I'm telling you, just kind of acted like you kind of didn't really know what you're doing, and they would have said, "Oh, this will be fun. Let's just bring this guy to trial." And then suddenly you show up and smoke him.
I mean, like, that's the thing, is everyone wants to put her on the stand and ask her these questions, right?
Yeah, and now you don't have the chance unless
we prevail on the appeal.
So if you fundraise enough money, $50,000, you can appeal. And what are the chances? Like, what would you say? Like, in the appeal, in layman's terms, I mean, listen, let's be honest. Your IQ is 1,000 times bigger than mine. I can't even believe that. Well, you led this team to this point. It's unbelievable what you I don't know how you're gifted.
It's kind, but like I can't predict that.
What I'm saying, just explain it to me like I'm dumb.
This is how it works: is so it's a new judge. In fact, there'll be 3 of them. There's a panel of them. They're all appointed by the government. That's just how it works. That factor you have working against you. But appellate level courts frequently overturn decisions of lower courts. This happens every day. That's why you have appellate courts and why you have separate judges. We've identified definitely mistakes that he made in his decision. So in order for a decision to be reviewable, some reason why an appellate court has to say there was definitely a mistake made, is it comes down to one of two things. There's either an error of fact or an error of law. And errors of law are more significant. And we have grounds in both of those. When he makes a mistake that's an error of fact, it has to still be material. So it's what's called the overriding. Palpable and overriding is the language in the courts. Palpable means like you can see that there's a mistake, but overriding means that it was actually significant, that it determined the outcome, right? And so we've cataloged quite a few, and some of them we've disclosed on our status updates on our website, but there's more that we're uncovering.
You don't want to show your whole hand.
We don't want to show our whole hand because it's not just because we're trying to keep our powder dry, but I could be wrong, right? We may find out doing more reading that actually there was this case law that said, that's not an issue or something like that. But there were, we've got quite a bit that we can take to the Court of Appeal. Now, my prediction is that the BC Court of Appeal likely will say that mistakes were made. Whether or not those mistakes were of sufficient gravity to change the outcome, that I can't know. That I can't know.
But if you don't file, then we'll never know, and we're locked in with this.
$50,000 is not a lot of money. I've seen people in the anti-lockdown movement, spend significantly more than that on other things. And like if you distribute that over all of our fans, but that's the problem, is that when you're shadow banned, people don't even know that we're doing this. We don't have a big marketing budget, right? Like I'm an engineer. I don't manage our social media or anything like that. That's really not what I went to school for. So, we're good fighters. We do the combat, I think, effectively in court. But when you have an army, you still need to provide it with beans and bullets. Otherwise, it can't do its job, right? Even if they're willing to do the fighting. And so that's kind of where we're at, right?
Yeah. Damn. And so you got to raise this by what date?
Very soon. So it's, I think you said it was the 9th or 10th today?
Yeah, 9th today.
So it's the 9th today. Our factum is due on the 30th. We need, I would say, to do it well, I would like to give our council enough runway, at least 2 weeks. So that's not a lot of runway. That's not a lot of runway. We don't have to raise it all of it immediately now. If we can raise it over the coming weeks, that gives our council confidence. And she's been very, very reasonable on her bills. Very reasonable. She's not doing this to get rich. This is the kind of work that will prevent you from getting rich.
Oh, yeah. Any lawyer that would take this on, you're getting a big target on your back.
Exactly.
It's like you had a target on your back.
Yeah.
I've had a bit of a target on my back in the past, and I'll probably get a target on my back for even having you here today.
Yeah.
So thanks for that.
Yeah. Yeah. Well, it's very rare that you see any progress or change in history that where someone wasn't offended. That's just history, right?
Yeah.
Because you always have some vested interest that stands to gain by keeping things the way they are. And we're obviously trying to change things, and the government's not happy about that. But we have always been a credible threat to them. We were not,
the fact that Bonnie knows your name.
Yeah, I mean, like, it was only one case that she mentioned. I think I mentioned that maybe it was the last time I was here, where it was, I think the CBC did an interview with her years ago. It was just on Christmas Eve, or no, I think it was around New Year's, and they were asking her if she had any New Year's plans, and she said something along the lines of, like, she's going to keep the champagne on ice pending the outcome of the class action. And at the time, there was, as far as I know, there was only one, so that was us.
That must have felt good.
Yeah, it was good. It was
creeping in her dreams at night and making her sweat a little bit. I mean,
someone from the Department of Justice or the Attorney General's office, Provincial Attorney General's office, probably had a meeting with her and
said, "This guy we might not want to f with."
Well, they do that anyways, but they hadn't seen anything like this, I think, coming. They knew that there would be lots of legal challenges, and I'm sure there's a large pile of internal memos we'll never see from the Attorney General's office advising them that, there could be a significant number of legal challenges. But I don't think that they were thinking that they would see a class action challenging the underlying declaration of the emergency itself. Because most people, they just don't think like that, for one. And two, most lawyers wouldn't have thought to do that either. They would have wanted to do something narrower. But even if they had prevailed in that, and one demographic is able to go back to one specific church and one specific municipality, it doesn't really have a huge effect for all the rest of us, or 4 million people.
If you raise the money, let's say you win the appeal, what is the dumbed down version of what you want to happen? You go to court, the trial happens, everything gets put on the table.
Yes, everything gets... It depends what the decision the Court of Appeal makes, but the Court of Appeal has the authority to change basically any order that Justice Crerar has made. I'm kind of simplifying this, but in this situation...
Yeah, simplify it, please.
In this situation, they can substitute their own discretion if they choose to, if the certain test is met. And if that happens, they can say... They have options on the menu. One of them is they can say, we think he made mistakes, we're pointing out those mistakes, and we're remitting it back to the application judge. It could be him or potentially a different judge to reconsider our application for certification. Or they can just say, to hell with it, we're just going to, it's in the interest of justice that we just substitute our own decision, right?
And go to trial.
Yeah, well, as soon as you're certified,
it's on.
That the next step is discovery. They'll still try and fight us and so on, but it would be much harder for them to do that once we have a decision from the Court of Appeal, because the Court of Appeal, they have the decisions that they render of greater authority than the lower court, the Supreme Court of British Columbia. But if another option is we don't win in the Court of Appeal, and if that happens, there's still a potential avenue for redress in Ottawa. We would go to the Supreme Court of Canada. You have to ask permission. You don't have an automatic statutory right to go and appeal to the Supreme Court of Canada. You have to ask permission. And there's a test to be met, and it's kind of vague, but basically things that are in the national interest and class action challenging the COVID measures that affected, millions of people, in my view, would meet that test. But there's other considerations that apply before you can get into that gate, But I think that we do have a chance in the Court of Appeal. And if we can get there, really our problem isn't capability. We have some very good counsel that can work on that file, in particular, Polina Fertula. She's been amazing to work with. The public has been very happy with her work. She's worked in this file with professionalism. That's been incredibly difficult to do, but she's done an amazing job. And we have other counsel as well, Omar Sheikh and others who can assist, because an appeal it's a big job. It's
Dude, all of this seems like a very big job, a very large job.
It is.
Large job.
It is, and when I was in the military, we used to call it asymmetric warfare, where the one side has all the resources and the other side doesn't. But you can still win. Yeah, and that does happen.
Yeah. What are your thoughts on? And I've honestly been tapped out and doing other things, being a dad. Focusing on the things in my immediate world. Well, trying to keep my finger a little bit on the pulse of what's been going on, obviously, but. This new virus that's going around.
I think this is a heptavirus.
Yeah, heptavirus. I just started getting hearing about it in my algorithm a couple days ago.
Yeah.
And I'm like, oh, how long has this thing been around for? And if they're already setting up something else happening, and this trial is still going on, and they're going to implement some of the same tactics if they even dared. I mean, it'd almost be stupid. I think too many people are awake now, I hope.
Well,
for them to do that again. But then you're already into another virus fight. Well, we haven't even solved
exactly
how the last one was handled legally or correctly. It's just, I don't know.
There's been zero accountability.
What are your thoughts?
Well, my thoughts are that Bonnie was actually on the CBC. This is very recently. I think it was in the last month or two. Yeah, I think it was on the morning show on CBC. And
how did I miss that?
Yeah, exactly. Great way to start your
How did the entire country miss that?
Exactly. Yeah, so she was asked by the anchor, how do you think the words to the effect of basically do you think the world would react to if you had to do this again, like if there's another virus? And her answer, I don't remember the exact words that she gave. I listened to it a couple of times just to make sure I heard it correctly. But basically she said that the public would be expected to comply again. So that tells you, and then with what you were just talking about, that they have not foreclosed on repeating all of this. And if we do not have closure on this case, and like I said, this is the last avenue for collective redress, then when it does happen again, and I'm telling you it will, we can't complain. We can't complain. Because we let it happen, and $50,000 distributed over 4 million people, it's not a lot of money, right?
Yeah. Today's money is constantly losing value. More gets printed, purchasing power is dropping, and over time your savings buy less and less. You see it at the grocery store. If everything you own is inside the system, you are exposed. Banks can restrict access. There's lots of videos online of people trying to withdraw $10,000 cash. They're harassed by the banks. It's insane. So, what are you doing? Gold and silver gives you a way out. These are real physical assets that exist outside the system. It's just value. They can't be printed. They've stood the test of time. They hold purchasing power. Everyone's talking about this. They give you real control. You own it. No permission needed. There are two ways to feel safer that I've used and would endorse and recommend to you. The Salmoney Wallet is a platform that lets you buy physical metals online. $5 here, $100 there, whatever feels good. It's stored in a military-grade vault, waiting for when you need it. Of course, you can ship it to your home, 3 days FedEx. You can even sell it back and have the cash immediately put back in your bank account if you need it. Millions of people are feeling uneasy about leaving their savings in the bank. Salmoney Wallet is a great solution. Another strategy is you can move your RRSP into gold and silver. Remove the risk of market crashes, maybe even be pleasantly surprised with a sharp rise in the value of silver, as so many experts are predicting. So give yourself something most people don't have. Real control, real security, real peace of mind. Find more of how I do this at kidcarson.com/gold. All right. Well,
They make a big deal about, this is a crowd-funded campaign, but so is theirs, right?
yeah, we're all paying for.
Exactly.
We're paying for the people that we're battling against.
And you don't even know how much they're spending. You can find out roughly how much they raise, but you don't really know where it goes. Like, we're pretty transparent. People can look at our books. Anyone can go on the GoFundMe page and see how much we've been raising. And she's been making an issue about that. Bonnie wants us to reimburse her for her legal costs. I don't think that's going to succeed because the
Really?
Yeah, I mean, when Parliament drafted the Class Proceedings Act, like they said, if you don't get certified, the presumption is the other side doesn't get costs. They don't get reimbursed.
So she's using our money.
Yeah, well, she never paid anything out of pocket.
Yeah, it's like they're using tax money.
Exactly.
Right? For their case.
Exactly.
And then they want us to pay back the money that she took from
some
us.
portion of it, right?
Yeah.
Which they're going to exaggerate into some massive monolithic figure. But the problem with that is, remember what I said about why we didn't get certified? One of the core reasons that they gave. So right now she's saying they have deep pockets. Look at their GoFundMe page. They've raised $500,000. And it's like, that's true, but that's over the span of like 5 years. It's not a lot of money, especially the team's not taking a salary, all the administrative stuff, insurance and phones and hosting, email, all of these things. It's not a lot of money. Like, no nonprofit runs off of, that. And so there's a conflict of narratives because we didn't get certified. She was saying we don't have the resources. Right? And now she's saying we have deep pockets. So which one is it? Right? Her counsel has a duty of candor to the court to not mislead it. So do we have some secret stash? Because I'd love to know where it is, right? And we put it towards this appeal. But this is the kind of stuff that I have to deal with. It's when I go into court and I'm listening to what's going on and I see their arguments, like, I hear circus music in my mind. It's like, it's kind of a dark comedy, like a Monty Python skit or Saturday Night Live, Mad TV or something like that. And they're in costumes, they're wearing suits, and it's just bullshit. And it's not just some lawyer. It's like that's supposed to be an advocate for the public interest. That's the attorney general. That's our lawyer. That's there, publicly funded, supposed to advance the public interest. And the things that they would say about our stakeholders was appalling at times. Like, we had nurses running out of the courtroom during the certification hearing because it was like PTSD, being traumatized, You've been mugged or raped or something horrible has happened to you. You're a victim, and then your abuser is up there in front of a judge basically telling you that you deserved it and you did all these things wrong, and so they were running out. I saw a lot of it, and it was hard. It was hard on me because, like, I'm an engineer and I'm trying to do this. I can't be everyone's therapist at the same time, but that's what was happening, right?
Wow.
Yeah.
Wow. Oh, dude. Okay, well, I know you don't want to be here all night. I know you got plans, so I'll put the link to the GoFundMe.
I appreciate it.
I'll get a couple clips for Instagram so people can share it around.
Yep.
So if you are listening to this, go to my Instagram page, find one of the clips from this interview, share it with your groups. I guess if you're a part of a group, there are a lot of still WhatsApp groups and Signal groups of people, where there's thousands of people in there. Just spread this around.
Yep.
And we can't let this not be followed through.
SueBonnie.ca, and then just click on donate, and you've got lots of different options.
Okay.
Lots of different options.
Brother Kip, thank you, my man. Thanks for sticking with it, because, man, it's just exhausting hearing about it. I can't imagine being the guy.
I don't like to give up. I like to see things through to the end, even if you fail. Just finish what you start. What you start. Let's see where this goes.
Right on, dude. Thank you for coming in.
My pleasure.
Appreciate this.